Be given 10 minutes to present their case with 5 minutes for rebuttal. And lastly, after the case is over, if you wish to discuss it further, we would ask that you leave the building, as if you go into the back foyer area, it does echo into the chamber. This time I would ask you to rise for an invocation by Commissioner Randolph and the Pledge of Allegiance from Commissioner Davis.
Gracious Father, once again, we come to you to say thank you for all the blessings you've bestowed in our lives. Thank you for this day. We thank you for the health, strength, senses, and sound mind and bodies you've blessed us with. We thank you for your creation. Thank you for this parish. Thank you for our state, Lord. We thank you for this government, Lord, and all the employees that work therein. And we thank you for this commission. Help us to make decisions that's in the best interest of all. We ask in your name. Amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. In our packets, we have the March 8th, 2016 minutes, which the Commission has reviewed. Are there any comments or any motions regarding the minutes?
Move to approve.
We have a motion by Commissioner Richard to approve, second by Commissioner Lauren. Any further discussion? Hearing none, I would ask for a vote. Motion carries. This is a public hearing. The public is invited to speak on behalf of or in opposition of any cases that we may hear. Entering parish right-of-way, servitudes, easements. Entering parish right-of-way, Harrison Avenue, Ward 3, District 2. Request to enter parish right-of-way for the purpose of gaining access to property. The debtor, Dragonfly Enterprises, Incorporated. Parish Council District Representative, the Honorable Dennis Sharp. Staff?
Yes, Mr. Chairman, the petitioner called me this afternoon about 3 o'clock. He had a car accident yesterday, and he's incapacitated at this point. Asked me to ask the commission if they would politely postpone this until the next meeting.
Thank you.
Motion to postpone.
Second.
We have a motion by Commissioner Davis to postpone, a second by Commissioner Randolph. Is there any further discussion? Hearing none, I would ask for a vote. Motion for postponement until next month carries. Minor subdivisions, 2016-232-MSP. A combined 29.496 acres into parcels A, B, C, and D. Ward 2, District 2. The owner, Dennis Glass. The surveyor, John Cummings and Associates, Inc. Parish Council District Representative, the Honorable Dennis Sharp. Staff?
Thank you, Mr. Chairman. Reasons for the public hearing is that more than one lot is being accessed by a private drive. The owner has a total of 4 existing parcels. 2 elongated parcels facing Louisiana Highway 1129, and 2 10-acre parcels that are currently landlocked, located behind the highway frontage parcels. I'll refer to your survey. You can take a look at that. The owner wishes to kill 2 birds with one stone by reconfiguring the highway frontage parcels to face Jim Sharp Road and create a private drive off of Jim Sharp Road that will provide access to the 2 landlocked parcels to the east. Since the proposal complies with parish code requirements, the staff has no objections to the proposed minor subdivision request, subject to the following comment. A private drive must be constructed and/or improved to meet all applicable parish road construction standards pursuant to Section 40-045 minimum construction standards for a private drive of subdivision ordinance regulatory ordinance 499, prior to the survey plat being recorded for public record.
Thank you. Is the petitioner here? If you'd please come to the podium, state your name and address.
My name is Hugh Fitzgerald. I'm here on behalf of Mr. Glass. He had a
prior commitment and couldn't be here. Here just to answer any questions that I might for you. It's pretty well straightforward. Mr. Keller covered everything I think that I know about it. Otherwise, what we see here is that the parcels that he has now, the long, narrow parcels coming from Highway 1129 were only 157 feet wide. They were landing strip lots. So the two parcels, Parcel A and Parcel B, are much more uniform. And then he's agreed to build a road giving access to the two 10-acre parcels in the back. And be glad to answer any questions if there are any.
Thank you, sir. Is there anyone else in the public who wishes to speak in favor of the petition? Is there anyone who wishes to speak in opposition? Not at this time. I close it to the public and I bring it to the commission. Commissioner Willie?
Yes, Mr. Fitzgerald's right what he was saying. This is north of Barker's Corner, way up in the northern part of the parish. It's a good common sense solution to a problem there, and I move for approval.
Motion by Commissioner Willie to approve, second by Commissioner Richardson. Commissioner Davis.
Question for staff. We don't need a variance on this since A and B are less than 5 acres, is that correct?
That's correct.
Thank you.
Any further questions? Seeing none, we have a motion by Commissioner Willie to approve, second by Commissioner Richardson. Please vote. Motion carries. Petitions requests. A request to build on a buildable substandard lot of record located in Forest Glen Subdivision, Square 100, Lot 1, Ward 7, District 7. The petitioner, Amanda DeMarino, Parish Council District Representative, the Honorable Jacob Groby. Staff?
Thank you, Mr. Chair. And pursuant to Section 40-034.01, contiguous lot rule of subdivision ordinance 499, the Planning Commission is responsible for reviewing requests for building on a buildable substandard lot of record. And again, as the Commission is aware, that is a lot that is under a 50-foot frontage. The petitioner is requesting to build on a substandard lot of record in order to construct a single-family residence. I believe they're actually trying to relocate a home on this property. So a slight correction there. In order for the Planning Commission to approve a request for a building on a buildable substandard lot of record, the petitioner must provide proof that they do not currently own and has not sold, nor has any predecessor in deed or title sold any contiguous lots during the period following the initial adoption of the contiguous lot rule ordinance on January 20th, 1994. The petitioner has satisfied the requisite requirements of proof as referenced to above. However, the petitioner wants to move a house onto the property that measures 28 feet by 30 feet in dimension, and therefore cannot meet the minimum side yard setback requirements of 5 feet on the interior side and 10 feet on the corner side. Now, again, I refer to the site plan behind the staff report that shows the lot and what it would look like to be set onto the property of the house. Therefore, for that reason, the staff recommends denial of the request and suggests that the petitioner seek alternative measures to either place or build a structure on the property that will comply with the parish minimum setback requirements. If the commission decides to grant permission to the petitioner to place the house on the property in violation of parish setback requirements, the approval should be exclusively in favor of the owner of the property and must be acted on within 1 year from the commission's approval. Secondly, the commission does not have the authority to waive parish setback requirements, only to grant permission to build or place a structure on a buildable substandard lot of record. Therefore, if the commission approves this request, the owner of the property will have to file an application with the St. Tammany Parish Board of Adjustments to seek variances for the side yard setback requirements.
Thank you. Is the petitioner here? Is there a representative for the petitioner? Is there anyone in the public who wishes to speak in favor of this request? Is there anyone in the public who wishes to speak in opposition to this request? Seeing no comment from the public, I would close it to the public and I will bring it to the commission. Commissioner Randolph.
I'd like to move to postpone to next month's meeting.
Motion by Commissioner Randolph to postpone until next month's meeting. Commissioner Lauren.
I was going to make a motion to deny, whichever was appropriate.
We have a motion by Commissioner Commissioner Lauren to deny. We have a second by Commissioner Richard to deny. Commissioner Davis.
I agree that I think we should postpone this. I know this area very well since I live out there in Lacombe. It's unfortunate that somebody isn't here to represent Amanda or herself. There's a lot of information we could ask, like who owns the lot next door? Can she purchase that and that? So just to deny it and go right to the council, I think maybe improper move for us. I think we should maybe at least give her the benefit of the doubt and maybe try just postpone it for one more month.
So, I was going to say,
I'll second
no,
it. I'll second
Commissioner
the
Richard
motion
is
to postpone.
parliamentarian. Second the postponement motion pursuant to Commissioner Richard's Robert's rules. Correct me if I'm wrong, Commissioner Richard, motion to postpone will take precedence over a motion to deny. So we do have a motion to postpone till next month by Commissioner Randolph. We have a second by Commissioner Davis to postpone. Is there any further comment? Please vote on the motion to postpone. The motion to postpone carries. Entering the Tammany Trace, we have none. Revocations, closing review, we have none. Re-subdivision review, 2016-234-MRP. Hanson Meadows Farms, Lot 21 and 22 into lots 21A and 22A, Ward 2, District 3. The petitioner, Woodruff L. Camus. The surveyor, John E. Bono and Associates, Inc. The owner, Woodruff L. Camus. Parish Council District Representative, the Honorable James Red Thompson. Staff?
Thank you, Mr. Chairman. The applicant is proposing to do a lot line adjustment in order to provide Lot 21 public road frontage, which said parcel is currently devoid of same. Technically, a waiver of the regulations are required because the lot width frontage given to proposed Lot 21A, which is only 121.77 feet, is under the A1 zoning district requirement of a 300-foot width. However, as stated above, currently Lot 21 does not have any public road access, and by adding the 121.77-foot strip of land to said lot, will provide it with legal access. Therefore, for that reason, the staff has no objections to the proposed re-subdivision request. If the commission decides to approve this request, a waiver of the regulations are required relative to the lot width issue, and a two-thirds majority vote of the full membership of the commission, 8 members, is needed in order to approve pursuant to Section 40-100, waiver of regulations of subdivision ordinance 499.
Thank you. Is the petitioner here? If you please come to the podium, state your name and address, ma'am.
My name is Carol Camus. I'm the wife of Woodruff Camus. And we have that one piece of property that is landlocked. And the gentleman that is interested in buying that 20-something acres needed access. And so we came to conclusion that we could put in this portion, sell him that extra piece, so he could have access. And since it's very rural out there, no one is having a problem with it.
Thank you, ma'am. Is there anyone else in the public who wishes to speak in favor? Is there anyone who wishes to speak in opposition? Seeing none, I close it to the public and I bring it to the commission. Commissioner Willie.
Yeah, I don't know why we have all these landlocked pieces up in Folsom area up there. But yeah, it'd be fine. It's a good common sense solution for it, again. I move for approval with the waiver.
We have a motion by Commissioner Willie to approve with the waiver, second by Commissioner Richard. Are there any further comments? Please be reminded this will take a 2/3 majority or 8 votes of the commission to carry. Please vote. Motion carries.
Now what?
have to wait, by law, you have to wait 10 days to record your surveys in the courthouse. So just give me a call in about a week, about 2 weeks.
Okay, sounds like a plan.
But
Thank you.
you've been granted your request.
Thank you.
You're very welcome. Dormant subdivision review, we have none. Tentative subdivision review, we have none. Preliminary subdivision review, we have none. Final subdivision review, we have none. Proposed amendments to ordinance 499, we have none. Old business, SD 04-06-018F, Penn Mill Place, Ward 3, District 3. Developer owner, Corey Herberger. The engineer, Kelly McHugh and Associates, Inc. Parish Council District Representative, the Honorable James Red Thompson. Request to amend commission requirements for pile pier foundations within flood zone A. Staff?
Penn Mill Place subdivision received final approval in September of 2007. Meeting subject to punch list items. One of the stated items, all homes located in flood zone A4 must be constructed on pile pier foundations and no fill to be placed on lots. Final plats have never been furnished to the parish for recordation. Ownership of the property has changed hands, and the new owner is requesting that this requirement be amended, eliminating the necessity for pile pier foundation. The developer's engineer submittal dated March 16, 2016, copy attached, has been reviewed by the Department of Engineering. The review confirms that the proposed revisions to the plan where the lots in flood zone A4 will be filled to an elevation of 30 and a comparable amount of excavation will be removed from the detention pond conforms to current parish ordinance regarding cut and fill and no net fill areas of the parish. Therefore, the Department of Engineering has no objection to amending the requirements for the pile pier foundations within flood zone A4 and Penn Mill Place subdivision and recommends that the Planning Commission approve the revision.
Thank you. Mr. Marone?
Thank you, Mr. Chairman. Paul Maroon on behalf of Mr. Herberger, who is the new owner and developer of Penn Mill Place. As Mr. Watson just noted, the request this evening is to amend that requirement on the final plat requiring pier and pile construction. This matter was approved back in 2007. I was not involved at that time. Mr. Herberger was not involved at that time. Neither was Mr. McHugh. So we're not exactly sure of the genesis of that requirement. However, we do know that the elevation on the lots in question that we propose to place fill is about at the 29 or above elevation. So we're only talking about less than a foot average across these lots. We're not talking about an enormous amount of fill to get them to the 30-foot elevation that we're talking about. As Mr. Watson also noted, and as you'll see in your packet, we have provided cut and fill calculations that show we will actually be removing more fill from the subject property than we would be placing on these lots. So with that in mind, given the relatively small amount of elevation change we're seeking, it doesn't seem to make sense to have pier and pile construction that goes up less than an inch. So we would respectfully request your approval to amend the plat to remove that requirement, and I'll be happy to answer any questions that any of the commissioners may have.
Thank you, Mr. Marone. Is there anyone else in the public who wishes to speak in favor of the request? Is there anyone from the public who wishes to speak in opposition? Mr. Hernandez.
Carlo Hernandez. You know, I don't want to speak against the request. What I really want to speak against is the procedure that's being used for this. You know, it's under old business, and those of us who get the agendas beforehand, this item was not on there. And it's interesting, just for your information, the official journal of the items that are listed, 1, 2, 3, 4, 5 items listed on tonight's agenda, only one of them was in the official journal, and that was number 2, which you acted upon. The other, of course, 2 of them were postponed. One of them you acted favorably, but you know, it's curious that only one of the 5 items was on the official journal list. And this one, of course, I think they requested it because they knew under old business that it didn't need to be in the official journal. Therefore, somehow it cuts out 1 month of the procedure in this. So, you know, and since it hasn't been moved since 2007, one would wonder why there's a need to eliminate 1 month on there. Now, the other thing is, those of us, and I looked again today in Ordinance 499 and the state requirements, and there are some inconsistencies there. And I would venture to say that if I were, and I believe 499 is under review now, I believe, and I would venture to say that 499 should have a requirement where any item that's on the agenda for the Planning Commission should be required to be on the official journal. And I know that there are several requirements, and I could talk to you about the requirements for notice, official notice, and one would question whether the ones that are not official journal in the official journal this past go-around, whether they were in fact necessary to be there. And I would say that I think it's marginal for 2 of them. One of them clearly, and that's the one that's on there, is on there. I would say that the two others would be marginal whether they should be on there or not. And certainly the one, and I guess the final subdivision request, where now we're using the old business routine to get around that, one would question, well, why is that? Is it because under that we don't have to put up signs on the you know, in front of these properties? And I'm wondering if that's the reason, then again, I think we need to look at, and I'm talking about section 40-440, again, hearing requirements notice, where it talks about the requirements. And in the last paragraph, which is not numbered, says, in addition, it shall be the obligation of the Department of Planning and/or Department of Engineering to ensure proper public notice by way of signs being posted on or in the vicinity of the subdivision at least 10 days prior to the public hearing. Said sign shall indicate the date, time, and place thereon. The same shall be reviewed. And I suggest to you that 4 of the 5 did not have that, or was not a requirement. And I'm wondering why that is. I suggest to you that in order to give proper public notice, that we should not only have it in as official journal requirement, and also have the required signs to be there too. Thank you.
Thank you, Mr. Hernandez. I'm going to ask counsel a question relative to this. Pursuant to Mr. Hernandez's inquiry, the particular case under old business, as we are going to address it this evening, followed all proper procedures as old business for us to hear and rule on this particular case this evening.
I think, Mr. Chairman, before I respond, I would like to ask the planning staff the procedure that they follow with this type of request that enabled it to be placed under old business. And then if the answer hasn't been fully given, I'll be happy to comment beyond that.
Thank you. Staff? As far as
I'll take a shot at it. I mean, this particular item was put under by the engineering department, but as the commission knows, for years and years, we have had old business items that relate to subdivision developments. What I think Carlos referred to in the code about public notice and the date and the time is actual phases of a subdivision or a subdivision that's in the approval process. Things that are after the fact are old business items, which typically are not advertised. And also further, what Carlos said, he is correct. The staff is looking at 499 collectively to determine whether or not other items that we typically handle without requiring anything in our public journal or newspaper advertisement should be advertised. Carlos mentioned that he said he looked at the, I don't know if you're referring to the website and said at one point he didn't see something that was on our agenda. Well, again, to let the board or refresh the commission's memory as to how that process works is that, as you know, our agenda is a work in progress, and then unlike the zoning commission where they can provide things well in advance, sometimes we have these old business items or entering the right-of-way items that don't have a specific deadline that you have to submit. So we try to give the benefit of the doubt to the applicants to get their stuff on the agenda as late as we possibly can do, and still be able to review them and come up with a collective decision on what to recommend or deny or whatever the case may be. So because of that, we post an agenda on our website, and we clearly state on that that it is a preliminary draft agenda, so the public is aware that it's not a final agenda. They're welcome to call our office at any time and ask us any information on that agenda or possibly what we may have in the works. Then approximately 1 week, as you know, you receive packets from the Planning Commission on your Zoning Commission nights. That day before that, on that Monday, is when we have a final packet, and we repost on the website a final draft agenda, and we include the meeting packet that has all the information that you get on Monday. So there's approximately a week period that the public has to review that information and to contact us for any questions that they may have.
Thank you.
What I can add to that, Mr. Chairman, is at least as far as the Penn Mill Place matter being placed on old business, I think it's fair to say that this is a very unusual case. To have a final subdivision approval to be granted by this commission 9 years ago, and then the final plats not be recorded following that, at least begs a question in my mind, why weren't any steps taken to find out where the difficulties lied in recording the final subdivision? It was merely the responsibility of the developer under our rules to provide copies, 18, assuming that was the same 9 years ago as it is now, to parish government of the final subdivision plats in order for them to be signed by the appropriate authorities and then recorded. Why that didn't occur, it may have been that the original developer shortly thereafter went bankrupt, went out of business, whatever. In either case, the question now becomes, okay, you have a final subdivision that's been approved. Now it's being proposed to be amended. What is the appropriate procedure? Well, obviously, the part of that appropriate procedure would be placing it on the Planning Commission's agenda for consideration of the amendment request, which has been done. The second part of that question would be where on the agenda would it be appropriate to be placed? I would suggest that there is only one place, and it would be under old business that would be appropriate under the current listing that this commission has of agenda topics. And so I don't see anything legally incorrect with the way that this matter was handled, given the nature of it being a very unusual case.
Thank you. Mr. Marone, you have a statement
Just a
or
few
question?
follow-up questions, Mr. Chairman, to follow up on Mr. Keller and Mr. Savant's explanation. I would only add a few points, and one is that I would note that what we are requesting this evening is not a material change from the subdivision. We're not changing lots. We're not changing the drainage plan. We're really not changing the substance of what was approved. What we are asking for is the modification of what became a punch list item at final that really deals with ultimately the later step after final, which is typically in your permitting department, which is the building of the homes. So as Mr. Savant laid out, it's an unusual situation, even a little more unusual in that what we're talking about is really an issue that is most typically dealt with at permitting. So as far as what the commission back in 2007 would have seen at tentative preliminary or final, that is not changing but for this very one minor punch list item. So I would respectfully suggest that in my tenure appearing before the commission, items such as this that are not material changes would have typically appeared under old business. So when that was the approach, it did not seem odd to me, given my experience at all. But with that said, we again would simply request your approval. We followed the procedures that were laid out to us. They appear to be correct to us. I think your legal counsel and senior planner have confirmed that. So we would respectfully request your approval this evening.
Mr. Savant?
Mr. Morone, please correct me if I'm wrong, because I'm relying on the information that's included in the packet. The final subdivision plats have not been recorded for this subdivision, correct?
That is correct.
Okay. And so that would be something that would have to occur following this meeting before the development begins the permitting process.
That is correct.
So I would suggest that perhaps the new developer consider including a note on its final plats referencing this meeting, and if the approval is granted for that, so that potentially to eliminate any confusion in the future about what it was that the Planning Commission ultimately approved as far as the construction of those lots. I don't know if you feel that's appropriate, but my concern is knowing that the general vicinity of Lake Ramsey has areas of drainage concern, and I'm not saying that this development is going to have any of those drainage concerns, but you know, going forward, when these homes are built not on piers, it may be useful to have a reference on the final plat that approval had been granted for the non-pier constructions by this commission.
Sure, we would have no objection to adding that note for clarification going forward.
And based on what we've just heard, it appears from staff and from council that, again, all the proper procedures were fulfilled on this particular case regarding old business. However, as Mr. Hernandez does point out, and the fact that we are reviewing our procedures, there might be consideration for the future that there be a posting and a time for old business, but that would be a future consideration where this has fully complied with, again, our current policies, procedures, and legal requirements. So we thank you all for that. Commissioner Willie.
Yes, Paul. Based on what Mike was just saying, I'm assuming none of the lots have been sold yet. The developer still owns all
Correct.
the lots.
That is correct.
Okay.
That is
that's
correct.
one. And on the agenda, it says with the foundation within flood zone A, but in the letter, it says A4 flood zone.
Yes.
So is there,
There really is no distinction. The portion of this property that is in A is A4. So it's really
okay,
one and the
'cause,
same.
You know, I don't know if we have, how we say it in the proposal. Yeah, I don't have a problem with the proposal. I move for approval.
The motion by Commissioner Willie to approve. Commissioner Davis.
Yeah, Paul, one more question. So you're saying that since September 9, 2007, no action's been taken on this property, correct?
There has been some action to try to correct some of the siltation and issues that have occurred over the years to get the property back into shape. Yes, so there has been some, but we're still, there's still a few items that need to be completed because of the long delay.
Okay, a question for legal on this. I know when we grant tentative and preliminary, they have to act on these within a certain amount of time period. But once we grant final approval, this could then realistically, they could just wait 20 years and then build it? Or do they have a certain amount of time in which they have to have final completed?
Realistically, this kind of scenario doesn't occur. It's an unusual circumstance. And while our regulations in 499 talk about the final subdivision review and approval and the recording of plats process, it doesn't, to my knowledge, establish a time frame in which that is to occur. In the review of the 499 regs for any amendments, that perhaps may be something that is looked at, but right now, there isn't a trigger, if you will, of some action being required if the recordation doesn't occur within a particular time period following final subdivision approval by this commission.
Okay, and if something had happened in final subdivision within these last 9 years that we added, they would have to meet what the current, what the final subdivision would implement now. Let's just say we said that you know.
Well, I would have to defer to staff because I can only make the assumption that when this application was made by the new owner and developer, the staff reviewed all of the requirements that would typically be done for subdivision final approval process to see if anything has changed over the last 9 years to perhaps require a recommendation that the new developer do additional things to the property, kind of like what Mr. Marone referenced, that the property had to be cleaned up. You know, keep in mind that all or most of the infrastructure, I'm assuming, has already been put in place.
Correct.
And then laid dormant.
Correct.
And I'm thinking that what Mr. Marone is referencing is that needed to be cleaned up in
That's
order to
correct.
be in a position to go to staff and say, okay, this is our situation, we just need this little tweaking, but we're ready to do the final recording and start moving forward with the sale and development of lots.
Thank you.
Commissioner Richard.
Hey, Paul. Obviously, this happened before our time. How many lots are in this subdivision? And of that, how many of them fall into this classification?
There are 58 lots in the subdivision, and utilizing the new flood zone A line, which has not yet been adopted, but it is, the new line takes in a bit more of the subdivision, so we use that line. Even though it's not adopted, there are almost 30 lots, I think, that would fall within the A zone.
And so that's approximately half of them. And on average, you said we're talking about a foot?
Yes, actually, a little less than a foot on average.
Is there any extremes there, too, that we need to know about? I mean, is there 8-foot ones and some
No.
2-inch ones, or?
No, they're all,
Okay, we have a motion? I'll second the motion.
We have a second by Commissioner Richard. Is there any further comments, questions? Therefore, we have a motion by Commissioner Willie to approve, second by Commissioner Richard. Please vote. Motion carries. Is there any new business to come before the commission? If not, take a motion to adjourn.
Here is your current